Welcome to the Website Takedown Podcast, Domain Justice with Scott Austin.
Hello and welcome to the Website Takedown Podcast, Domain Justice with Scott Austin, a Florida bar board-certified intellectual property attorney and founder of the Website Takedown Guy. Scott helps business owners protect their brands from cybersquatters, phishers, and online abusers around the world. My name is Kevin Rosenquist, and today's episode is Cybersquatters, Phishers, and Trolls. Oh my, we're going to look inside the battle against domain name abuse. Scott, good to see you.
Good to see you, Kevin. It's nice to be here.
Before we get into the tactics, can you sort of paint a picture of what domain name abuse actually looks like in practice?
Well, for those who have witnessed it firsthand, the sad thing is that it usually shows up through someone that is very important to you, and that would be a customer. Someone phones you, emails you, texts you, and says, hey, I visited a site and I thought it was you, but it seemed something was odd about it. Something was different. And domain name abuse shows up most frequently as an impersonation website, what we call a copycat site. And that is probably the most common. The way that website is fashioned can determine whether it is sort of classic cyber squatting or if it's phishing. When we talk about phishers, they're obviously a little play on words, but that's a lot of what the cyber squatting is about. There's also something called typo squatting, where someone has actually changed the domain name, your domain name, slightly by creating a typographical error in it. That's a typical one that users would often make when they were trying to search for your site.
Yeah, I've definitely gone to some of those before, inadvertently.
No, that's the whole idea. That's the plan. And the phishing, as my quote, which I think I came up with this, is that for lack of trademark, phishing fails for want of a hook, because the hook in phishing is a trademark. It's typically a famous trademark or a well-known trademark. But that doesn't stop these folks from using, and when I say folks, I'm talking about people who engage in the practice of bad faith use of abusive domain names. Doesn't stop them from attacking all kinds of websites related to small businesses as well as large and well-known businesses. I've had, as someone who's been a member of a panelist for both the World Intellectual Property Organization based in Geneva and the Forum based in Minneapolis, Minnesota. Those are two leading domain name dispute resolution providers that are essentially the arbitration forum groups that administer domain dispute proceedings. And so they are the ones that often have the greatest capacity to demonstrate what kind of abuse has occurred through the caseload and the cases that have been decided through their services. The point is that phishers are typically someone who has used a trademark to get users to end up at their site, and their site looks like someone else's site, looks like the official site of the trademark owner, but instead it's being used to get email addresses, sometimes get financial information, sometimes even get medical information, depending on the type of site, and that's the danger. And then trolls are really someone who's out there that just like a troll under a bridge, they're essentially monitoring who is using a particular domain name, and they will troll for the ability to retrieve a domain name when it expires, for example, what we call drop catching. So those are three of the types. There's many other ones, and cyber squatting also includes things like malware, ransomware, again, impersonating a site to get somebody to come there. And sometimes it's not even a website. Sometimes it is an inactive site, but still they've configured what we call MX and FX records so that they can use email, and they will use an email that looks like that owned by the trademark owner and a trusted person within the trademark owner's business, such as someone who's head of finance, a CFO, even a CEO. They have been impersonated in order to get information, in order to take out a loan, for example, in order to change receivables and redirect them to a different account, and in order to get job applicants. unsuspecting people who want to work for that company, instead of sending their resumes to the official company, to the real trademark owner, they're sending them to some other website, giving away all of their personal information, sometimes paying money to these people for phony job applications. It's a very, very miserable business, and it's something that really has to stop. And that's why we feel so strongly about it at the Website Takedown Guy.
For a business that suddenly discovers one of these imitation lookalike domains, how can they tell whether it's just kind of an inconvenience or a true legal problem?
Well, the short answer to that is use what you know to be as the official contact information for the trademark owner. See if you can go online, do your own search, and come up with a location that tells you with absolute certainty that this is the real site, the real website, the real owner of that business, and call that number or send that email to determine if in fact someone is spoofing them, is pretending to be them. That would be one way to do it. The other way is call us, call the Website Takedown Guy, and we'll be happy to lead you through the process of how you can confirm that is in fact the legitimate owner of the website.
What makes phishing especially dangerous for brands today?
Well, I guess in one sense, it's because it's so easy. The anonymity is all. The fact that people are able to obtain a domain name with very, very little disclosure of who they are, and the verification process for that, at this time anyway, is extremely minimal. It really does not determine. I mean, it's more difficult to get your driver's license at the local DMV than it is to get a domain name.
Right.
And unfortunately, as long as it stays that way, that's the problem we're going to have. So phishing has become prevalent. It's obviously inexpensive for them to pretend that they're someone else in terms of getting the domain name and creating a website. And so the real question is, how can someone who wants to use the internet, or someone who uses the internet for their business, protect themselves?
When a company wants to take a domain away from a cybersquatter, what's the process? What are the options they have available?
Well, the most important option that we look at, there are a number of tools. The Uniform Dispute Resolution policy and the procedure that's used to force the transfer of a domain name from the person who's abusing it and has obtained it in bad faith and is using it as bad faith. If that can be demonstrated by complying and meeting the criteria under that first procedure and policy, then that's one of the most effective tools, because it has the benefit of being expedited. It's a short process, unlike regular litigation, which could take months or even years. And it also is extraterritorial. That means that it goes beyond one particular jurisdiction, whether it's a jurisdiction of the person who's been victimized or the person who's actually the abuser. And that's thanks to the benefit of many people, many really great people who were essentially the founders of both the internet and also the developers of the UDRP. We stand on the shoulders of giants, and I say that because there was no process like this when the internet first started. Sure. There was an absolute requirement for it. And so the people who were involved, many of them very fine trademark lawyers and corporate lawyers, and folks who were very involved in the administration and the governance of the internet and its founding stages, decided that the need was for a policy, and how could that be implemented on a global basis, because of the fact that people who use the internet obviously are from all over the world. And they came up with this process with the UDRP that's based on an arbitration concept. And the arbitration comes through an agreement, and that's your registration agreement that you sign when you purchase a domain name. And all registrars and registries and registrants, the person who actually let's say leases the domain name, are required to participate in that, and they're bound by that. So that is a tremendous benefit and a tremendous tool, because, as I said, it has that extended reach that allows you to go on to a website that has a dispute resolution policy in place with a dispute resolution provider like WIPO or the Forum. And there are others, many other fine ones in other parts of the world as well. But those are the two main ones. And the nice thing about each of them is they have a fairly substantial body of precedent. And I'll use that term. Some people consider it because it's not a traditional court system, but it certainly is a body of cases and decisions that can be drawn from to determine what kind of facts have been sufficient in order to meet the requirements of the policy. And we'll get into that in a little more detail. But the point is that that is probably the most effective tool from a cost standpoint, from efficiency standpoint, from a timing standpoint. Now, the other tools, obviously, I would be remiss if I didn't recognize the fact that you have litigation that's available to you in various jurisdictions and all over the world that deal with the types of claims that would be involved in the improper use of a domain name. In this country, in the United States, we have the Anti-Cybersquatting Consumer Protection Act, or ACPA, ACPA, and that is a very useful act. But again, it is traditional litigation, which means you're going to be filing a complaint, which means there's an opportunity to respond. There are ways that too can be expedited, but it's going to take more time, and frankly, it's going to probably take more money. Compared to the UDRP, which has a cost factor of $1,500 or $1,330 for a single member panel, and it goes up from there for multi-member panel, a 3-member panel. But the bottom line is that traditional litigation, because of the fact that it does employ the courts, and the courts have their own calendars, and it's you have to follow that calendar, will take more time. So then another tool that is extremely important, but it's in a different realm. The UDRP really relies on, or is based upon, trademark concepts. Not necessarily, it starts with infringement, but infringement is slightly different than abuse. Abuse is a broader term, and it covers more things than trademark infringement. And there's different standards for evidentiary standards and for meeting the requirements of the policy versus what you would find in traditional trademark law for infringement. But the point is, UDRP is more focused on what someone's trademark being encompassed or used, at least the predominant portion of it, in a domain name. On the other hand, when it comes to a website, you can also have what's called the Digital Millennium Copyright Act, which involves copyright, and it has to do with content. If, for example, in a Copycat website, there are proprietary images, digital images that you have on your website that have been screen scraped and put up at the new site, then that is copyright infringement. Mm-hmm. And that is the subject of the DMCA. And the DMCA is a very, very effective tool and a very timely tool because it has essentially a 10-day requirement, a very short time period for things to be taken down. And because of the way that it works, there is somewhat of an upstream chain of people that could be subject to liability if it isn't taken down, because there are some very specific benefits, safe harbor benefits given under Section 512 of the Copyright Act that protect hosts and people who are providers in that chain for website development and operation. So there's more than just the person who did the screen scraping that has something at risk. And that can be very helpful to you, at least to get the attention of the person who is abusing not just your trademark in a domain name, but also your copyright protected information, which can include text, it can include images, as I said, graphics, even look and feel in certain cases. But the point is, it's a very valuable tool. So I think that's sort of the beginning. There are other elements that can be added to that, but that's really sort of a summary.
Some brands try to buy up every possible domain variation of their name. Does that work? Is that a decent strategy?
We would always urge clients, when they do come up with a trademark, to take a look at the available domain names, both obviously .com, because that is sort of the king, the most important GTLD or generic top-level domain for use in business. It's the one that most users remember, and that's why it's so important. But there are so many others now. So you can have obviously .info, .us, which, by the way, has a slightly different UDRP that goes along with it. and it is exclusively under the jurisdiction of the forum in terms of resolution of its disputes. But it's another option. The question is, how many other domain names besides .com is it likely that cybersquatters would use? And the truth is, they'll use whatever works. And there are times that, I've handled many decisions, several hundred decisions, and most of them have been in the .com realm. The abusive domain has ended with .com, but there have been all across the board, including .io for input-output, or it's actually a location because that's what we call a country code top-level domain. And those are usually related to a particular region or area that has ownership of it. For example, it's been assigned to it. .us is what you would expect, but .tv is Tuvalu, which is, I think, in the South Pacific. But that's been taken over by people who obviously want to use .tv. So someone else serves now in the registrar aspect or registry aspect for the operation of that CCTLD, country code TLD. But my point is that in terms of what you want to get, that doesn't seem very expensive at first to purchase these domain names, but remember, it also requires the maintenance, it requires the renewals, it requires making sure that somebody doesn't get them. So the more that you can focus on the primary .com, .org, .net, and some of the other ones, .info, those are really the main areas. But if your mark is very well known, the sky's the limit, essentially, or your budget is the limit in determining what really is possible. The more important expenditure, I think, is in using something that is a watch service that is out there tracking the primary part of your name, which is the second level of that domain name, the thing that comes to the left of the dot, which encompasses your mark. And that's the thing that really more money should be spent on, is a valid watch service.
Okay. Looking ahead, how do you see this, domain abuse evolving, especially with AI becoming such a huge thing and deepfake content on the rise?
Well, it's a tremendous danger, and we've already seen warning signals in a number of areas because the number of the amount of cyber squatting has increased. It's spiked, and obviously there's different times of the year. Right now, we're in the month of December, and that's a time when anytime there are holidays and shopping and increased use of retail for bargains and things like that, Black Friday, those kinds of things, that's increased use of the internet for retail. And a lot of times people allow caution to go to the wind because they're more focusing on what they're trying to do for someone else with a gift or with giving. And so I think that the big problem that we have today is there are so many that people have begun to sort of accept it as part of doing business, as part of what happens out there. And it doesn't have to be that way. With the proper protective treatment and the proper focus in terms of enforcement and someone getting there quickly, it sends out the right signal. And that the other part of that is that if you do have a trademark, use a circle R, and if it's registered, use a circle R. If it's not registered, use a TM. Use something that sends out to the world that you treat this as your trademark. So many people will put up what really is a mark even before it's become registered. If it's what we call a common law trademark, there should be something that provides notice, because that will help not only tell the bad guys that you do treat this as a mark, and it's going to be seen as that if it ever comes down to some kind of infringement action or a UDRP. Because I've had situations as a panelist where someone did not use any kind of reference to their trademark, and it comes off as not taking the trademark law seriously, and the fact that that trademark has substance, that it's something that's very important. So I think it's extremely important, and one of my warnings to users and to those who own trademarks is please continue to use a superscript R if you have a registered mark. And if you don't, then use a TM, which is obviously for trademark. in the same manner until you get it registered and work toward registration, because an unregistered mark is much more difficult to prove in terms of evidence that it's obtained what we call acquired distinctiveness or secondary meaning to users, to people to consumers in the marketplace. And there are ways that you can accelerate that process. Even there are cases that have shown that someone who is a startup with a tremendous product or a tremendous service can actually show an accelerated acquired distinctiveness or a secondary meaning. But again, it all comes down to evidence. The most important thing, you asked me what new threats are a business about to face. In addition to AI, there is something that's been around for a little bit, maybe a couple of years on the horizon, and that's Web 3.0 or blockchain domain names. And that really does present a whole bevy of problems and possible difficulties in terms of finding out who's responsible, again, for abusing trademarks and abusing rights holders and their ability to protect their marks against some kind of abuse through blockchain or those kinds of domain names, Web 3.0. So stay tuned. I think a lot of us have been shaking our heads in terms of exactly how that will appear on the internet, how it will be reached, and what means there would be for any regulation or any governing of that, because that's something that the folks who have developed that are not particularly interested in. And I think that we need to find out, just exactly how it's going to work. The UDRP has served well, and I think has over the years evolved to be a just means of protecting rights holders, but also protecting people who have a legitimate interest in a domain name that it may be involved in the secondary market for domain names. And that's something we'll talk about in another episode. But I think there's every right for people to invest in domain names as well and to use them for their purposes. But I think Web 3.0, we're still waiting for the results on that in terms of how it really will affect users and what kind of policy will be in place to protect trademarks.
Well, interesting stuff for sure. Thanks for that, Scott. And thank you for tuning in to the Website Takedown podcast, Domain Justice. To learn more about Scott Austin and his work protecting brands online, visit thewebsitetakedownguy.com. Thanks for listening. We really appreciate it. Please subscribe and review if you get a chance, and so you don't miss any future episodes. Scott, great chatting with you. Thanks so much.
Thank you, Kevin. Thank you, folks.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.